The chair is convening the 18th meeting of the Civilian Police Review Board. It's great to see everyone today. Pastor Reverend Tatum let me know that he would not be in attendance today. And so the first thing I would share with you is that it is my understanding that Gambit Aragon did not appeal his removal by the mayor, and so it is effective that he is no longer a member of this board. The next, pardon?
I said a quick question.
Mm-hmm.
I think, I'm not sure where it's in our bylaws, but it seems like when a member, and I'm not sure if this applies to Gambit, but when a member is on the board until they are replaced by another members, but.
That was not true with Aaron Thomas. So I'm sure he's not going to sit here. I mean, I'd have to have someone, or maybe Laura would know, but it is not my understanding that he sits here until his replacement. Is that what you're about to say?
So that was, well, there's my understanding in terms of, so for example, when people's terms end.
Which we're going to get to today.
Okay, but they're not replaced until somebody replaces them, is my understanding of how.
Yes.
And it could be different in the term
Yes.
versus a resignation versus removal, but that was just my understanding because I know we have a couple vacancies.
Okay. So anything further?
I would love further clarification on that in terms of the timeline, just in terms of thinking about when a member gets replaced. I know we have Thomas, who was vacant from the board.
I will be in communication with the mayor's office, and specifically because of what I'm going to share with you in a little bit about those terms that end April 30th.
Perfect. And
we'll try to ascertain when they expect to name new board members.
Got it.
Okay. Let's move to approval of the minutes. Is there a motion?
Motion.
Second? All in favor? I want to stop and share something with the board about these minutes. So what happens is that, and I've wondered about this from the very beginning in terms of what is required to be in minutes. So our process is that when Bethany completes them, she sends them to me. And I go through, kind of edit, whatever, and then she redoes them. You can only imagine what it was like for the minutes of the January meeting. So I reached out to our general counsel, Laura Baker Morrish, to see if we could find examples of how other cities actually handle this. And before I start, let's readily, we should know that there is a full record of the meetings that are actually kept, and so people can go back into, I don't want to call them mothballs, but can go back and see the complete minutes. So in the future, and so we looked at Cleveland and Cincinnati. So in the future, in terms of what you will see, unless there's been, I'd say, a significant discussion around a particular item, it would simply give the case number, the allegation, the recommendation, who made the motion, who seconded, and whether or not the motion carried. That's all you would see for each one. Again, unless it's one that warrants additional, information. So I wanted to give you a notice of that so that when you see the new format for this meeting, you will understand why. The next item before social media that I wanted to bring up, are board terms. And I have more papers up here today. So I think I mentioned this at our last meeting, but I reached out to the mayor's office to see how they wanted this handled. But for the record, in terms of individuals whose terms that end April the 30th of 2023, it's Pastor Rich Nathan, One of the vacancies, the one that Mr. Gambit was in, was one that would have ended. Kyle Strickland, Mary Younger, and interestingly enough, also Aaron Thomas, that will be replaced, and myself. So for, I think it's 2 or 3 of you, including me, the mayor's office would like a communication from you by March 1 that would indicate, I guess it's 1 of 2 things. Either that you no longer want to serve or you wish to continue serving. I'm going to ask Bethany to send this out as an individual communication to you. It appears that all matters somewhat connected to the Civilian Police Review Board are now being handled by Rena Shack. She's in-house counsel and assistant policy director for the Office of the Mayor. So what Ms. Shack requested of me is that in an email, in the body of the email, you would be addressing the mayor, but it's going to be sent to her. And so Bethany will send out, maybe even as early as tomorrow. I have her contact information, so please expect to see that, and please respond to the mayor by March 1. Yes?
Question for clarification, if we could maybe, when we think about doing our bylaws and or policies and procedures and practices, just more formalizing that in terms of as a board, making.
I'm sorry, I don't understand what you mean.
So, you know, because we have standard practices or procedures as a board that we had discussed talking about, and I think I don't know if there's anything indicating the actual process for, you know, renewing your term, other than what was just outlined, that we email the mayor's office and let them know. But I'm just saying in the future for our board, I think it might make sense if we just put that in writing about what the process is. And then I did have a question about, does city council then?
The mayor has to make the decision
And then
as to whether or not you are reappointed.
And then from there, does city council have to
I actually don't recall. Yes.
Okay.
So yes, then city council has to approve again. Yes.
And the term, if we chose to stay on.
Would be a 3-year term.
So we're signing up for a 3-year term?
A 3-year
this time?
term.
Okay.
Yeah, remember, we only did this for the initial board because if we had all had 3-year terms and served
Yes.
2, we all would have rotated off, which would have been very problematic for this board going forward. Would you pass this down to Brittany? Her contact information is there. And I would also just say, because I sent, and I was going to talk about this later.
Links then.
Pardon?
In that communication, we'll get the links to Rena's email or?
She's going to send it out
Yeah, so,
separately, her contact
With the-
information, her email, phone number, yes.
great,
And I'm asking her to send it separately, not just to include it in the minutes.
great.
Okay? And I just communicated with Ms. Bishotti, and I think she told me this once before, but quite frankly, I wasn't sure what it meant when she said all things Civilian Police Review Board and all things Inspector General now reside with Ms. Shack. So the question that I sent to Ms. Bishotti has to do with the report that we must generate to go to City Council. And I just wanted to know who was kind of the contact person. I would have thought it would have been Robin Davis, his communications person. But again, she referred me again. So just so that, I think I mentioned this before, but just so you know, she is I would say the mayor's staff person who is our direct link. So I think now, one other thing. You noticed me take a phone call, and I don't do that in meetings, but it was someone responding to an inquiry that I made yesterday. So after our board meeting, you remember the motion to permit virtual committee meetings? We sent that to City Council, and we hadn't heard anything. So I reached out to Council President Harden yesterday, and he told me he thought he could get back to me today. Well, evidently, I think he's had some communication with his staff, and he realizes he needs to get the city attorney's office involved. But they want to move forward with this, but we probably will not have a completed action by city council until March. So just keeping you informed on that issue. And now a revisit and hopefully an action to be taken of the social media and media inquiries for Civilian Police Review Board. You have received a copy, and I think most of us thought that we had actually acted on this, but I guess the minutes don't reflect that. So I would start by just asking board members, are there any other questions or concerns about the document and the policy that you have before you?
Yeah, the question that I would have, well, one, I'm glad we're getting a policy in place to approve. I think either it connects to this policy itself or how we handle these matters as a board, which is, how we handle or how we're going to think about handling any perceived violations of the social media policy, right? And so one of the things that, was discussed potentially is maybe a range of kind of discipline options, right? Thinking about as a board, because there are certain instances in which, repeated violations might warrant a different approach than, singular violation, or violations could be seen as egregious. So, I don't know if that connects to the policy itself or how the board handles it, but I did want to put that up for discussion.
I don't see the two connected.
What's
I think
that?
we put the policy in place, and then if we're going to visit the issue that we have raised, that's separate, but they're not connected. So I want, if at all possible, for this policy to be put in place.
So, but the question I would have there, though, is that, what happens when somebody violates the policy?
My point to you, Mr. Strickland, pardon? No, is that we can take a look at that issue if the majority of the board members want to, but it is not connected to having a policy. And I think, and it would be in this area, I think I have suggested before that if, and maybe not for this specifically, well, let me stop and put it this way. Would there be an interest in a subcommittee, subcommittees usually 3, for me, that would look into the issue that Member Strickland is raising? Yes?
I have a question.
Okay.
I don't know. It was a question.
Okay.
So because we convened a subcommittee to basically create the framework for this policy, and Mr. Strickland was a part of that. So would that be the same subcommittee that would perhaps
It doesn't
look
have to
into
be.
the-
No.
Oh, okay.
No, it does not
and
have
then
to be.
The other thing is, I think what Mr. Strickland is thinking about are procedures, and that's typically separate from the policy.
Yes.
And so we have not created a procedure that would be that action item taking place because we're just focused on the policy right now.
Yes.
So maybe the subcommittee could then come up with whatever that procedure would be.
If I could, I probably think, because I doubt social media in and of itself is going to be the only question arising around what sort of discipline or steps of discipline have to be taken, then I would suggest it's a discipline policy, either added to rules and regulations and amend those to add an addendum that talk about discipline regardless of what the perceived infraction is, if that makes sense. Because I agree.
I agree with you.
I don't think it should be tied to one thing.
You chair rules and regulations.
I do.
So again, I'd like an action on this matter on social media, and then the chair will ask the chair of rules and regulations to, and with your subcommittee, to look to the broader issue of discipline, potential discipline of a board member. That would also include the discipline for the violation of this policy, but it might also include other things.
And yeah, and then I just want to be, if possible, if we could maybe set aside some time specifically for an action on that item in terms of the procedure, because, I don't want to be in a position where we're putting policies forward without having a procedure for discipline. So, I'm fine to vote on this and support this, but I do think it seems like that's going to be a priority, is making sure we have a procedure in place for that, or a discipline policy.
I appreciate your point, but the chair would now call for a motion to approve this policy. Yes.
I would like to just have a point of clarification.
Okay.
Regarding this, inasmuch as we had an instance of that involved the misuse of social media, at least in our opinion, even though we didn't have a policy that had been approved, would someone be able to just share with me what points of this would have been violated had this been in place? What points would have been violated by Member Aragon's activity? Just how, since we have a concrete instance of this, I'm just trying to understand the application of these phrases to what.
One and two. You would have violated 1 and 2.
I hear, although not into the microphone, from board members to my left, that in their opinion, it would be items number 1 and 2. Now, the chair is willing to entertain, because I did think about this, Pastor Nathan. Should we, and certainly not tailor it, but since we have a lived experience, that certainly involved social media and a board member, the chair would be willing to not ask for this to be passed today. And I'm not sure who had this. Pastor Nathan, you had it the second time. Which committee did this come from?
It was Kyle, Pastor Nathan, Brooke, or was Pastor Nathan Brooke? Were you
Yes.
part of it?
The three of us.
Yeah.
Dr. Jones.
It was who?
The three of us and Dr. Jones.
Would you like the opportunity, and not to do it today, and again, I'm keeping this very, very separate from this issue and discipline, but would you like the opportunity to go back with what we have, this draft, and give thought to what Pastor Nathan has just raised?
I understand that you see it as separate, and I can see some separation to it, but without having a discipline policy in mind, it's kind of hard to understand what the application is for a violation of 1, 2, or 3, right? Because you could imagine certain violations would warrant more discipline. So that's my only concern, is perhaps we can
Your
also
concern
add-
has been expressed. I am referring, who chaired that committee? This.
I think I did.
Was it you?
It was
Okay.
I refer this back to that committee, led by Pastor Nathan. And again, I'm going to ask them to review this and to see if there are any changes that might be made in light of our lived experience. And then for the issue of discipline, what are my committees?
Rules and
Mark and I
regulation.
are
Rules and regulations.
But we probably need an additional person because Gambit was on rules and regs.
So for rules and regulations, there are 2 committee members. Is there a volunteer for a third? Mary? Thank you, Member Younger. So she's the third. And let's put some time frames on this, because I think it's very important that we get this passed.
The social media policy will be pretty straightforward.
Okay. So social media policy by our March meeting. Let's try if we can for rules and regulation, but I understand that might be too fast at the outset of the April meeting. Okay? Thank you. And I just wanted to, I really thought about this, well, actually, I don't even know if the policy would have changed what I said to this reporter. I was unaware until today that the Department of Justice was going to release its report about the police until today. And a reporter sent a written request at 10:13 this morning, which I then think was forwarded to me, how we did it. And she wanted me to meet her here before our 2 o'clock meeting so she could interview me. And I told her, I mean, and this is just kind of practical going forward. I said, I don't even know if this is a matter where a member of the Civilian Police Review Board would in fact be interviewed, with an exception definitely of Dr. Jones because of her work. But I said this to her, I am not going to be interviewed about a document that I haven't seen. That is not how I operate. And I know with reporters, they want to be there right at the minute. And just from my perspective, I just think it would have been totally, inappropriate in terms of the time frame. But while I'm talking about that report, I don't know the size of it, the length of it, but I personally, as a member of the board, and maybe others, would just like to see a copy of it. And maybe it's online, it's just a matter of a link being sent to us. I would just be interested to see what is in the report. So if, Bethany, if you can do that, great.
It's only 14 pages.
It's only 14 pages. For me, I need it so I can print it.
Yes.
I understand it's only 14 pages.
And full disclosure, I did conduct an interview with the media today about that DOJ report, but it was more so about the press conference that happened, not actually the report.
Right.
If that makes any sense.
Now with,
Madam Chair,
yes,
point of order. I know that traditionally that we only have 3-people committees, but rules and regulations is really a pretty serious thing, and I would like to propose that we add Mr. Strickland to our committee.
I'd be cool with that.
I'll consider it, make a decision later. Let's get started with our review of, and again, I think there's another maybe, before we get started with the actual going over the assignments, I believe you will find before you a document that was prepared by Dr. Jones that might be helpful. It's called the Investigation Review and Report Out Worksheets. Is that it?
Yes.
Yes. And remember at our last meeting, we talked about an effort to sort of streamline the report outs. And so, Dr. Jones, would you like to walk us through this and share your thinking?
Yeah, so I took the investigation review worksheet and added just a few sections that would make it at least a little bit easier for you to find the pertinent information to report out during the actual board meetings that we have. So if you see, it starts off with the complaint number, so that'll be easy for you to find. How the complaint was classified, you can select, whatever was in the actual report. What are the findings? But what I added was this section in summary of the incident. If you all remember from the last board meeting, we were asked to just give a synopsis or a summary, and people were flipping through pages trying to find it. So I just put a few lines there to make it easier so you have that information readily available. Another thing is that some of the groups, the subcommittees, had some concerns that they wanted to raise for us to address during the meeting. So I just put put right up front, what were some of the concerns that your group had, so you can outline them there, so you can explicitly state them as you are giving your report out. And then another thing is that many subcommittees also had questions. So there were some questions that came up as they were reviewing the investigation review worksheets. And so rather than having to flip through your notes and remember what those questions were, I put a section on this sheet as well, so you can just refer to any of the questions. And then one of the things that we noticed during some of those investigation reviews is that there was not just one allegation, there were multiple allegations. And so I added a section so you can write down each of the allegations that are brought up in the investigation report. And then I think those were the main things that I added to this sheet. And the purpose was just, so you, as you do your investigation worksheet, once you complete it, you can bring a copy of it to the board meeting and then just read off of that. So that way, it'll streamline some of this information. You won't have to flip through a million different pages to get the pertinent information.
Let me also share with you that I have received recommendations from I.G. Hendricks, and I believe those recommendations were also that Attorney Ross also was involved in that. I'm not prepared to accept this. I need to read it. I may need to actually have a discussion. And again, I was out of the country when this came to me, so the time frame has just been very challenging. But by seeing what Dr. Jones has, I'm not saying that we can't incorporate some of your recommendations, but I'll do that before the next meeting. So to the members, do you have any questions about the document that you have before you from Dr. Jones?
So I don't have a question, and certainly I like easier and simpler, which brings me to an ideal that I had and I brought up in a meeting. We don't have to go through it now, but I think what we're called to do is to review low-level complaints. So I think I have a solution to make this easier and simpler, because we're doing
Could you repeat your first statement? We're called to something
to
low level?
review low-level complaints.
Some of these complaints didn't seem low
No,
level to me.
no, and that's
Okay, and I don't mean to belittle, but they're not criminal complaints. They're, at least for mine, I'll speak for me, low-level citizen complaints. They're not felony complaints.
they're not egregious.
Exactly.
They're not egregious.
Right.
It can be egregious, potentially without being criminal.
Correct.
Okay.
So I was trying to think of a way to make this more efficient, because it seems like we're doing it, we're repeating ourselves. The IG's investigators have already investigated. They've already done the bulk of the work. We're simply reviewing it. But what we do is we all get a copy of the reports, our individual subcommittees. We then review them individually. We then have to get with our subcommittees to schedule an appointment to then go through the report again with our committee members. We then have to fill out the sheet. And then we have to, at least this time, summarize it so that we won't have to read, right? And so I think we're doing a lot for complaints that aren't egregious.
But isn't it our responsibility as individual board members, and I'll say it at the end, that we have to vote on each and every complaint that comes, that the IG has
Absolutely.
investigated?
Absolutely.
So I'm trying to,
So my idea was, instead of sitting out the reports to the individual subcommittees, send all the reports to all members. We read it. If we have any questions, we can write them down. We look through it. if we have any questions, write them down. The investigators who have already investigated the case, they can summarize it to us. We then vote, and we're done with it. The scheduling of the, going to the library or wherever you're going, writing out the summary, filling out this is a lot, I thought, for a complaint that's not egregious.
So, my thoughts are on this. This is where I was kind of thinking about that tiered process in terms of how we talk about these cases. So one, I do just generally think the idea of, so first, obviously, Dr. Jones, this is great. Thanks. The additions are good here. I do think just as a thought here, every member on the board should receive all the cases, should have the ability to review them. If they have additional concerns, can mark those down. How we handle the subcommittee and how those meetings happen is, we should talk about. But to his point here, as the board continues to get inundated with complaints of all levels, of all sorts, and I would say some egregious, some maybe less so, but of all levels, these complaints come in. You have the IG's office and the team of investigators that not only is it one investigator that looks through it, but there's typically a team of investigators sometimes that will provide additional support of it. They provide their summary sheet of it. And when we summarize the summary, it's possible that we might miss key parts. And so I just want to make sure we're on the same page there. And then so I don't want to be to the point where we're so inundated of just like double checking that we lose sight of the need to look at policies and practices and patterns that are emerging. But when we're looking just so individualized and not stepping back to saying, okay, how many, are these similar incidents, similar cases, similar officers? What is happening? What are the patterns? Right now, the way that we've been looking at, it's hard to identify where the patterns are. And so thinking about how can we set up a process, and other places do it differently, right? So and elsewhere, certain review boards, they actually might have the IGs or the investigator that did a particular case would actually present their cases. And then if we had further questions or concerns, we could make additional comments. So I think to your point, it does make sense for us to think about how we can streamline this process so that we're able to focus in on, making change happen where we want it to happen. So that's one thing I want to put out.
So there are a couple of comments here about that. It sounds like, Mac, you want to change it so that instead of reviewing our assigned cases, then that we review all of the cases basically and then complete a sheet. That to me actually seems like more work.
No completion. Yeah, you don't have to. No completion of the sheet. We eliminate that. We simply review.
I'm going to follow up, and I certainly don't want to make it personal. I heard Pastor Nathan just make a comment a while ago about the difficulty of scheduling meetings. And I'm going to ask each member to really think about this before our next meeting. You're talking about a lot of work for the whole board to read every completed investigation. And I think, Mac, that's what you asked for, that we would get them all and that you would read them all. I try to be mindful of the fact that most folks on this board, I think, still work and have other obligations. And even though I am allegedly retired, I think it would be very challenging for me to carve out the time to read them all. But I'm not making a decision, I would suggest that we start with using the document that Dr. Jones prepared for us. I will read the recommendations from the IG to see if again, maybe there's a part in that around streamlining. And also the considerations that, Mr. Strickland, raised. But I'm not prepared to change the process today.
Right. Now, if I can make one more point,
Yes.
just so we're clear, we would get all of the reports, but we're eliminating other things, the scheduling, the going over with our subcommittees, the paperwork. So we're eliminating some things.
So let me
Simply adding in.
just ask this of the three committees. So you receive and you read. Do you not find value of actually being with your committee members and having discussion before you make?
We, at least our subcommittee, we found a lot of value. And as a matter of fact, I think there was a comment about noticing patterns. We were able to pick up on patterns with officers being mentioned in multiple reports and everything, but we did that as we worked together.
And we've only really had 1 month of reporting out. Yes, excuse me. Yes.
So just a few things for us to remember. First, from a volume perspective, we do not yet know, 6 months, a year from now, how many reports we're going to be getting. And so the subcommittees were created as a way to avoid having every single board member have to review 100 reports in a quarter or a month. And I just to remember, we did have a meeting where we were asked who all would like to get all the reports. The only two people who said they wanted all of them were Janet and Gambit. Everyone else was fine getting their own reports. So I just want to remind us that even though this last month we only had 5 or 6 per committee, that's not necessarily going to be the case moving forward. Also, virtual meetings, hopefully it gets passed, but that will help alleviate what I feel like is happening a lot with our ability to schedule meetings, get together in person, and that's a hurdle and a frustration that I know we've now had 3 times and hopefully can go away at some point, which may also streamline part of this process, is being able to schedule meetings that don't have to take place, in alignment with an in-person. I have to drive somewhere to get to you. We all live across town. Lastly, I think that if we're up to changing after just a single month of report, we're going to change something every time. I feel like we can do better than what we did last month, and that we can figure out a process that works for our report outs, but I wouldn't go reinventing the wheel as of yet, because I think that we haven't even had a chance to gel even the first process we've put in place.
I appreciate those comments. Yes, Mrs. Strickland.
So I agree. Look, I don't think we need to reinvent the wheel, but I don't want to dig further into a process that I've already believe is inefficient. Not to any for lack of trying. It is like it is. We're just trying to figure out the best approach, trying to figure it out. But the challenges that I have with these subcommittee meetings in which these substantive conversations and discussions are happening, these are open public meetings, these substantive conversations are happening. In some cases, if we're, I would like to have some of those substantive conversations as a full board, right? And when we as a board are having to go through every single case like this, and some aren't substantive, right, in terms of, because it's all been discussed in our pre-meeting, that's the concern that I have. I would want to think about a way that we could, get, whether it's a cover sheet or report that we get from the IG's office that kind of does an overview of X amount of cases this, and I know we have some of this, but X amount of cases, this time around, these were the findings, at a high level in these cases. And then we can tier it out that way so that I know what I'm getting, that everybody knows what they're getting, right? So I think right now it's really hard to step back and see, okay, how many cases are in my sheet here, how many cases are excessive use of force, how many are, misconduct, how many are, it would be nice to have like a high level overview of that so that we know going in at the top, okay, I may not have too many questions about, these cases here, but I know I have a lot of questions about these cases that I want to dig deeper on and spend more time on. That is just a thought as to how we could supplement this process. Because I think right now, also when we think about to the public, if somebody has their case that's coming up that they want to hear about, what's that process look like? So I think just more clarity about what cases are coming up and at what time should people come to these meetings.
To that point, and I did read this on the IG's report, she's making a recommendation that we do not include names of complainants and police officers because they are getting responses from complainants who don't like the fact that their names are being made public. We're going to move on. As I said, we can revisit, but I get back to my vice chair's comments. We've had one meeting. Yes, it was rough, but we're going to try today. And I have another suggestion. So Zoom would certainly be helpful. It would also be helpful if you, as subcommittees, if you could, you figured out the timing, right, of when we need to make public the meeting, et cetera. Could you choose a day of the week, one of the weeks, and a time period that you can do every single month like we do for this? If it's on the calendar, if you figured out that can work, and there are only 3 of you, and you stick with it, I personally believe that would take away a lot of the not being able to schedule meetings. If it's just a suggestion, you know, it might be different in terms of your work, et cetera, but it has worked for us as a board.
May I say
Yes.
one thing? I think what we have going here is, for right now, it's good. I think that maybe down the road, we may modify some things, but we have not given a chance to what we have. And I think whether the complaint is, in our view, small or isn't significant or not super significant, every single citizen deserves us to take a quick look. And all of us are smart enough to know whether we're going to spend 3 minutes on a complaint or 15 minutes on a complaint. And when we meet in our subcommittees, we know, we had 6 cases the last time. We know to spend 2 minutes on a case. We know what to do. We know how to move through it. So at this point, I don't know that we need any more from the IG than what they are giving us, and we can do it. We just need a little bit more organization within our own selves, I think. But I think that we need to look at every single complaint that comes through for right now, and we need to report on each one of them and review them. That's how I feel.
I agree. I mean,
It wasn't to belittle anybody. Heck, I might complain, right? And I want mine's reviewed and looked at. But I was simply suggesting, especially early on, because that was brought up, we just started. So I wanted to bring it up early on instead of going way down here and saying, hey, let's make a change here. Because actually the wheel hasn't been invented yet. We're simply trying some things here.
So
It's actually what we're doing, but
The first
I think it's
change we're going to
important.
make is the utilization of the new form that Dr. Jones has given to us. And that's essentially the only change we're going to make today. Again, I won't say it would be a change. I strongly encourage the subcommittees to try to choose a consistent day and time to meet. That will help you, I think, significantly. And with that, we're going to go back to the agenda. Item 3, review of remaining November assignments, and that would be from Board Member McIntosh, Team 3. You have, I think, 3 cases.
This is complaint number 2022-1, or -0134. This case occurred on August 4th, 2022. The complainant was stopped for speeding, refused to comply with the officers by not rolling her window down and giving her license to officers. She stated she was a sovereign citizen and can't be stopped by the police. Officers were finally able to get her out of her vehicle, place her under arrest, and impound her vehicle. The complainant filed a complaint with 3 allegations. The first allegation, Police officers attempted to break her car window when she refused to provide her driver's license information. Allegation number 2, police officers forcefully took her out of her car and arrested her. Allegation number 3, officers impounded her car illegally. Based on the BWC footage and the complainant's video viewed by the investigator, it was determined that allegation 1. The officers were not trying to break her window. They were simply trying to get her to roll her window down just enough so that the officer could put his baton in, open the door, get her out, which he was finally able to do. Allegation number 2. Officers used enough force necessary to pull her out of the vehicle. And allegation number 3, officers legally impounded her vehicle. Officers' actions were lawful and within CPD policies and procedures. The third officer on the scene, however, did use profanity. However, his sergeant was proactive and had already rendered positive corrective action. So it's my motion that we, the board, accept the EIG's findings of exonerated for all 3 allegations for case number 2022-0133.
Is that a motion coming from you?
Yes.
Is there a second? Second. Are there any questions from the board? I'm
In
sorry.
terms of, when your subcommittee met to kind of have conversation, discussion, did anything come up that, you had additional comments or thoughts on?
So the investigator examined the Ohio Attorney General's website, which said in part, if you determine that you're dealing with a sovereign citizen, the most important thing to do is to approach the interaction the same as you would any other person. If during the traffic stop the citizen doesn't produce a proper license, registration, or proof of insurance, proceed as you would with any other stop, which is exactly what the officers did.
Is there a second?
It was down
Just
there.
seconded. Before the vote, I would just point something out. Thank you for the clarity, the conciseness, pretty straightforward, and yet, as appropriate, there was a question from a board member that needed to be answered. So as we think about getting through these, I do not want us to, board members should have the opportunity to ask questions of these cases and have them answered. So as we just think about changes, keep that in mind. All in favor, please, of the motion, please raise your hand. Mr. McIntosh? Thank you. Motion passes. Your second case.
All right. Case number 2022-0137. The complainant filed a complaint with the DIG stating that CPD officers pulled her and her brother over without probable cause. There were 3 unsuccessful tries to contact the complainant. The IG investigator recommends that this case be administratively closed. I motion that the board accept the IG's findings to administratively close this case, case number 2022-0137.
Is there a second? Second. There were several of you. Any questions? All-
So it's just a question in terms of just a general process question of, I don't know if this can be presented to the IG's office. I can't really, I don't know if I can ask a question here, but in terms of what the practice is of, trying to reach a complainant and maybe not being able to get them after 3 times, I'm just trying to get a sense of what the practice is of all right, we've tried them 3 times and we've exhausted efforts. We're going to go to administrative closure, or, we're going to try one more time. I just wanted to get a sense of that.
So I will say it's on a case-by-case basis. Because we have 90 days in which to complete complete our investigations. When we get the complaint, we make at least anywhere from 2 to 3 attempts to contact the complainant, usually within a 2-week period of time, leaving them information on each time that we call, please contact us, we need additional information. Usually by the second to the third complaint, the second or third time that we call is to let them know that if they do not return our call within a certain date, that we will be closing the case. And that's simply because after 2 weeks, there's additional time it takes for us to get information, contact the officer. So we kind of feel that once the person files the complaint, it is also, up to them to make sure that us reaching out to them, especially if they give us a number in which we're able to contact them. And we do that not just verbally, but if there's an email, we also do an email and all of that's documented in our files.
Yeah, thank you so much. It's helpful. Just as a board, I think it's helpful just for us to know if we're talking about people who are having questions about the complaint process as well. Thank you.
All in favor of the motion? Motion passes.
Complaint number 2022-0176. On June 8th, 2022, the complainant's husband was killed in a fatal motorcycle accident. On August 18th, the complainant filed a complaint with DIG alleging that CPD officers have poorly handled the accident investigation regarding her husband's death by failing to include witnesses' statements to the report, by refusing to let her leave the scene, and by not returning her husband's firearm to her and incorrectly documenting the incident. The DIG investigator found that witness statements were in fact in the report on the supplemental sheet. Number 2, witnesses corroborated that the victim lost control of his motorcycle and hit or slid into the concrete wall. 3, the officer stated to the complainant that he couldn't take her to the hospital at the time because he had to secure the scene. Once another officer arrived on scene, that officer was asked to transport the complainant. And 4, in order to retrieve her husband's firearm, which was taken to the property room, she has to present to the property control unit a letter of authority or a release from administration order by probate court. So I motion that the board accept the findings of the DIG, that all allegations of officers be exonerated. Case number 2022-0176.
Second? Second. Questions? All in favor of the motion? Thank you. We will now move on to agenda item 4. We will first hear from Team 1, Pastor Nathan.
Yeah, my cases were a little more complex than yours. They weren't administratively dismissed for lack of contact with the, so you, Chair, if, just point of clarity, are we not mentioning the complainant or the officer's name? I didn't know what we were establishing.
So that was actually a recommendation. We could stop for a moment and I could hear from the board members. If we are receiving complaints, certainly, I should say complaints, concerns from individuals who have filed complaints about their names, I think, and I don't want to use the term policy, but I think we should respect that. And since we don't know who would and who wouldn't, and not state their names, and in a sense of being fair, if we don't mention the complainant, I personally don't think we should mention the officers. Any thoughts on that?
I agree. I agree.
You agree?
So I had thoughts on that. In terms of, with all this public records, right? So I'm just trying to get a sense. Are you saying, you know, we have everyone's names here, people can find their names, but when we report out, we're not sharing the names? And yeah, and then I just have a question from the IG's office in terms of even thinking about your own kind of practices or policies about, you know, when it's necessary to use a name and like what to do in situations of like minors as well. Like, what is the practice there?
So we have received some concerns about complainants' names being mentioned, to the point that one of the concerns came that it was a concern of even filing even complaints with our office because of their names being mentioned in the board meeting. So what we will say is that we know that everything is a public record, so anybody can request the public records and that information will be provided, but maybe to be consistent as far as how the board is reporting out, just to be consistent in the fact this isn't something, it's open to the public for them to be able to listen in, that if anyone wants more information about the record or the report, that they're able to do a public record request and get that information versus us just presenting it during the board meeting while we're discussing the cases.
And then just in terms of other IG's offices or civilian review boards across the country, what is your, have you had any insight in terms of some of those best practices? I do know some, like I think in Oakland, a few others, they don't read the names out loud when they're in these conversations, but it's readily available. But I just wasn't sure if other places did it differently, or I just want to make sure that we're consistent, right? And when you're reading it, just make sure we're consistent. But I just want to get a sense of other places as well, if you have any insight.
I have not done a research of, more than a couple. So what I will say consistently from where I came from, even when we presented the information on our website, we left the complainant's name out and just stated complainant. And again, most government agencies, there is always the public record for the request to be made for someone that wants more detailed information, but it has just been that they don't mention the name. They'll just say complainant, and the officer, they'll just, mention the officer.
Got it. Thank you.
So I would be more concerned about consistency for us here in Columbus. So for consistency, we will not use either the complainant's name or the officer's name. And I personally am not putting a burden on the IG that for everything she does, she has to go out and look at other places. I mean, there's a time for us to do that, but that certainly is, I'm sure, with her learning and her going to whatever. But personally, I am not one who's going to be held to what another jurisdiction does. Did we actually? No, I think we're just starting on that case.
Yeah.
Yeah.
We're just starting, so, okay. Here's the first case, number 2022-0183. It was filed on August 16th, 2022. The complainant alleged that the CPD officer did not enter the house of an individual who assaulted her son to obtain a statement, nor did they make an arrest. The facts are these, according to the complainant. On August 16, 2022, her adolescent son was assaulted by a 30-year-old man. Her son was walking outside with the assailant's daughter. When the officer arrived on the scene, he was told that by the assailant's girlfriend, according to the body cam tape, that the the assailant saw the complainant's son groping on his daughter. The assailant then got out of his vehicle, fought with the complainant's son. The assailant proceeded to kick the complainant's son in the face, causing a nose injury. He also pulled a gun on the complainant's son. The officer was informed that the assailant had been present at the scene but then went into his house. The officer told the group that he was unable to enter the assailant's home to search for him and that he could not force the assailant to speak with him if he did not want to. The IG closed the investigation with a finding of exoneration, claiming that the officer's actions were within CPD policies and procedures. Our subcommittee disagreed. The misdemeanor policy that was cited as the basis of the officer's response that he could not enter the house of the assailant may not be applicable because the assailant's actions may in fact be a felony. There are two criminal acts alleged. One is an assault based on the fact that the assailant allegedly kicked a minor in the face. The second is that he pulled a gun on the minor. In addition, the police report was insufficient. It did not accurately reflect the events that transpired. We recommend that the allegations be sustained and that this be sent to the police chief for additional training of the officer.
Are you putting that in the form?
Oh, so that's a motion.
Is there a second to that motion before discussion? There's a second. Discussion.
Go for it, Mayor.
Excuse-
So, who was questioned? Whom did the police question here? Did they question they questioned the complainant?
They
True?
questioned the complainant, they questioned the complainant's son who was
Okay.
assaulted,
Okay,
and they questioned the assailant's girlfriend who was not present during the assault. But they did not question the assailant because the assailant left to hide in his house, allegedly. And the officer said that he had no right to enter the house because this was a misdemeanor offense. And so we're not persuaded that it necessarily was a misdemeanor. There were two assaults. One, yeah, so you heard the report.
Can I be recognized, Chair?
Yes.
Board member, during the course of discussing this within your subcommittee, did anybody reach out to seek legal advice about whether or not those facts would or would not support a misdemeanor versus a felony?
We did not reach out.
No, but I did look up the revised code definition for felonious assault.
Okay.
Which is how we reached the conclusion that it would not be a misdemeanor, that if alleged, if true, that those facts would support a felonious assault allegation against the teenager.
Okay, because the reason I asked the question is that having my prior experience as a city prosecutor would suggest that those facts as described, again, I didn't see everything, would only support an aggravated menacing and a misdemeanor assault. Now, so again, there can be a conversation about whether or not my interpretation is accurate or their interpretation is accurate, but in terms of whether or not the officer did or did not follow policies or practices or procedures, I think you have to think about what the instruction was regarding how they are to interpret those facts as to whether or not they're a misdemeanor or a felony.
So in this case, is it your suggestion that the committee should have reached out to you, Mr. Furby, someone in particular?
I think, and in terms of who it might be, probably starting with Mr. Tobias as
okay.
right, as the attorney for the board, just only because, again, the determination of what facts support or don't support a particular allegation are exclusively within your jurisdiction and your purview. But in this case, the determination as to whether or not an officer did or did not follow policy has to do with how that officer did or did not interpret
Sure.
that policy, and that interpretation is itself a legal question. And so they would have to then get to what was he trained at the academy regarding what those facts and circumstances would or would not constitute in terms of, is it a misdemeanor or is it a felony? And if he was trained, and again, I have not seen the entire allegation, but as it was described here, kicking another individual and then threatening somebody with a gun rather than kicking them with a gun or causing a broken bone or shooting at them would all clearly be felonious.
He kicked him in the face.
Yes.
And broke his nose.
Yes.
So he did have a broken bone.
As I said respectfully, that would likely be filed as a misdemeanor assault.
Yeah, and I think that's why in our summary of our conclusion, we used the word may.
Right.
Because we were not entirely sure, but that was not the sole basis for our conclusion as well. There were other things, including the officer not questioning the alleged offender, as well as the report not accurately reflecting all of the events that transpired, because that subsequently prevented them
sure.
from seeking or going to the prosecutor.
Right, didn't mean to interfere or to question that whatsoever. I'm just more thinking about the fact that in this particular case, the decision about whether or not it is or is not a misdemeanor or a felony makes the determination as to whether or not that officer can or cannot lawfully enter the residence. And so he would have received training at the academy from Jeff Furby regarding whether or not, that determination is huge in terms of whether or not he can lawfully enter the residence. And that's where I was going with that. Again, I've not heard all the facts and circumstances. I'm just want to make sure that we understand what the training of the officer might have been regarding the legal aspect of whether or not he could or could not enter.
I was under the impression, though, that if you point a firearm at an individual, it's attempting to cause serious physical harm, which would make it a felony.
Threatening somebody with substantial physical harm, just the threat, is an aggravated menacing. It's a misdemeanor of the first degree.
And what was the recommendation from the committee?
That we submit this to the police chief for additional training.
I said a quick question on that. What was the what was the investigator's recommendation? And then,
Exoneration.
okay. And then, okay. Great. So like that's just a heads up, like that's an example of something I think is like worthy of discussion is when there's a kind of a disagreement with the IG's report, and I think.
Yeah, we have several.
And like, so I think like.
Ours weren't Willard's
Yes.
cases.
So those are kind of the types of things that I think worth discussing there.
I'd also like to point out, just for sake of the record, I imagine that you're thinking city code, and when I'm thinking revised code and threat of harm, which is where Mary just went, threat of harm with a deadly weapon or dangerous ordinance is felonious assault. And so whether Mr. Tobias would like to come give clarity on that, because
With a dangerous ordinance, but what kind of a gun was this?
I don't know that, I don't think it's in the
Right.
report, which all goes back to this
Right.
report wasn't accurately completed.
Right.
For purposes of the mother of the child to be able to even do anything about the assault that this adult
So
committed.
is this case at a point where it should be sent to the chief? Or is this a situation where there needs to be further investigation? In light of the questions that have been raised?
Oh, you talking about in terms of the legality of?
I don't know that
don't
we get
know.
anywhere with further investigation, because at this point, the police report that was provided didn't have all of this
Yeah.
information, didn't have sufficient information in it, which I think is part of
The issue.
the issue.
I do have a question in terms of, I'd be interested, right? The IG's office and the investigators came up with a contrary, really a different interpretation, and so I do wonder what that's about, right? Just in terms of why,
I'm sorry, I don't understand your question.
Well, in terms of thinking about process in the future, about how we communicate further, right? In terms of if we have a contrary decision, like I don't know in the future if there's a way to ask questions or present questions like, okay, we disagree with this, and this is, this is a set of reasons why.
We did at our last meeting, both in the meeting and then talked about reaching out when there are those little clarity questions. Yes, and I don't think we had clarity questions. We
Okay.
just disagreed.
Disagreed,
and-
okay.
Which we're allowed to do.
Yeah.
Like, we're allowed to
Yeah.
disagree with the
Yeah.
recommendation. But we did talk about that, being able to ask in the meeting and also before the meeting if there are things that can help clarify and help us get to a decision.
And the IG very helpfully offered, we're available. If
Yep.
you have clarity, questions, please reach out.
Got it.
So in that case, the officers didn't advise the complainant to seek
There wa-
out the prosecutor's office?
They did, however.
But the police report was
not-
insufficient.
Yeah, it was incomplete. So they really had nothing to present to the prosecutor's office to then conduct the investigation.
Are members prepared, I believe? Now, was there a motion?
Excuse me.
Yes,
Yeah.
okay.
There has to be
Madam
some-
Chair,
There has to be.
I'm sorry, I'm hearing Madam Chair.
Madam Chair.
Yes.
What I would ask the board respectfully, if you have questions regarding the report, is to reach out, because the report has a lot of information. There's a lot of, I'm
I'm going
listening.
to share with them your recommendation.
Yes,
Okay,
please,
yeah,
thank
not-
you.
Not at this very moment, but I'm going to share. And what I will probably do is, because I don't want to do things kind of shotgun, I will go through, read them, and we'll communicate with the board before, hopefully, the next meeting around, and that one was excellent in terms of how you want it to be communicated with. But it does also actually mean that in terms of scheduling committee meetings, they need to be done sooner rather than later. So if there are questions about individual cases that you want to send to the IG, you have time to send them and get a response and then move forward.
Yeah, we did not have clarity questions. We simply reached different conclusions than the IG did on the facts as we read them, but that's simply a matter of being different human beings, so.
And you're demanding that he be retrained for something that,
I did have a question in terms of.
recommendation was that they review as well as then whatever corrective action may need to be taken.
That's just case number
so
one.
there's a motion on the floor, yes?
I just had a question in terms of like the recommendation you all made as a subcommittee, and then, are we gonna get follow-up on that, right? So like if we move forward with the recommendation that you all made to the police chief, do we have a process for follow-up, whether or not that occurs or does not occur? If there's, because I do think that is important in terms of thinking about what our process is about.
No, at this point, we don't. That would be something I would have to work out with Chief Bryant. So for example, after our last meeting, we compiled all of the report, did a cover memo to her. They were sent to her, but I've not discussed them with her. I agree that we would want to know on certain cases, not all of them, what happens.
Okay.
Now, that doesn't mean we can do anything about it. I mean, these are recommendations to her.
Yeah, no, but I think that's just important for us to think about as we, whether it's in the minutes or in the reports that we do, as we make a recommendation, doing a follow-up to see whether or not that recommendation was followed.
I believe we covered that in a previous meeting, and we said that was something that Chair Jackson and the IG would need to follow up with Chief Bryant to come out with a process.
And it seems like that, but we'll,
No, it hasn't
It
happened.
hasn't happened yet.
okay.
Are we ready for a vote on this? Yes.
On this particular case, though, there are some officers who do a wonderful job on their U-10s, and the recommendation of training, does it mean training this particular officer, or what does training mean? Or just put something in the academy where all officers are trained as to how to write up a U-10? What does that mean, and what will it do to this particular officer who doesn't know how to write up a U-10? I mean, I'm
So
wondering.
I would think
should-
it's for this particular officer, so again.
That's what we meant, but,
No, but again, this is just our second meeting, and this is the first time I think I've heard allegations of the failure to properly fill out a U-10.
Yeah.
So I would feel very uncomfortable saying to the chief, all officers need to be
Right.
retrained. This one particular officer.
Okay, so maybe, should we be more specific in the, or, I mean, what was your recommendation to the chief? You said more,
That this officer receive additional
okay.
training.
Okay, that's good.
Chair Jackson, may I be
Yes.
recognized, please? In addition to that, I think it's important, I know some of you already know this, that it is ultimately the prosecutor's decision about whether or not to file charges based on information that's included in the U-10 report. And so I did not see this report beforehand, and I don't know if questioning of the intake office at the prosecutor's office happened to make a determination about what it was about said report, even if it was the report that was the reason in which charges were not filed. And so that is just also something to clarify. It is not the officer's ultimate decision. The officer can have a plethora of information in a report, and the prosecutor could still decide for one reason or another that charges aren't going to be filed. So that is just something to consider. The full discretion on whether or not to file charges is with the prosecutor's office.
Thank you. Any other questions? We're prepared to vote. All in favor of the motion, come. Motion passes.
Okay. May I move on?
Yes, please.
Oh, great. Case number 2022-0193 was filed on August 16, 2022. The nature of the complaint was that the officer failed to return a driver's license after conducting a traffic stop. Facts are pretty simple. The officer took the complainant's driver's license. There's no evidence to suggest the officer's failure to return the driver's license was anything other than unintentional. But the officer did not put the driver's license back in the CPD property room at the end of his tour of duty. Instead, he turned it in a month later. The IG found that the officer's actions violated CPD rules, and the allegations were sustained with a recommendation of disciplinary action. We agreed with the IG report.
So is that a motion?
So the motion is that his case be reviewed by the chief of police for consideration of disciplinary action.
Is there a second?
Second.
Second. Questions? All in favor? Motion passes.
Third case, case number 2022-0209, filed on August 29th, 2022. Complainant alleged that the officer was unprofessional, aggressive, judgmental, and racist. Second allegation was that the complainant's friend's rights were violated because he was placed in a cruiser without being read his rights. The IG found that according to body cam footage, the officer did behave in an unprofessional manner by using profanity several times, violating CPD directive, but there was no revelation of any racist comments regarding this portion of the investigation. The allegation was sustained. Regarding the second allegation, the officer's failure to read the complainant's friend his Miranda warnings, the IG found that the officer should be exonerated because he was not entitled to Miranda warnings, since this was a custodial interrogation. We agree with the first conclusion of the IG's office that the officer did behave in an unprofessional manner by using profanity. However, we are recommending to the IG that they confine their findings to whether the police violated their policies and not whether the complainant's Miranda warnings were violated. The wording of the findings suggests a legal conclusion concerning constitutional rights, and we just wondered whether this was beyond the IG's charge. We don't necessarily disagree with the finding of exoneration regarding this, but the wording in the IG's report suggests a legal conclusion that, in fact, the complainant's friend's constitutional rights were not violated, which we're not prepared to conclude. So we move that the first part of the first allegation regarding the officer's use of profanity be referred to the chief of police for possible disciplinary action be sustained, and we are recommending that the IG confine their findings to whether the police violated their policies.
Is that the motion? And is there a second? There's a second. Questions? Concerns?
So you guys had a problem with the friend being placed in the back of the cruiser or in the cruiser without being read his rights?
No.
Okay.
No, just that there's a legal determination that his Miranda rights weren't violated. Because oftentimes in these admin proceedings, let's say that he eventually got arrested and was charged with something. If he ever files a civil litigation against that, this specific finding about Miranda shouldn't foreclose a court's legal determination on that same question. So we think it should just, it's literally extra sentences that we don't think need to appear in reports in the future is so saying CPD hasn't violated policy is one thing, but making the legal conclusion that his Miranda rights were not violated, that's for a court of law.
All in favor of the motion? Motion passes.
Okay, case number 2022-0239 is filed September 1st, 2022. Complainant alleges that the officers raided her apartment because of a bogus complaint made by her husband. She was ordered from the house completely naked and handcuffed. She was asleep on the sofa and apparently unclothed. No female officers were brought on the scene, and she sat in the cruiser naked. The complainant alleged that the officers should have allowed her to cover herself. She felt disrespected and embarrassed by how she was treated. Apparently, she had gotten into an argument with her husband, who unplugged the video internet access camera. She claims that the husband made a false call to CPD, alleging someone was breaking in. When the officer arrived, complainant was asleep naked on her couch near the unlocked front door. The officer ordered the complainant out of the apartment. Another officer handcuffed her to a fence while she was unclothed near the front door of the apartment. She was then escorted in 1 minute and 20 seconds to the back seat of the cruiser. The officer then went back to the cruiser, covered her with a jacket 6 minutes and 15 seconds after she was handcuffed. And then 12 minutes and 25 seconds after she was initially handcuffed, they determined the complainant resided at the address, removed the handcuff, apologized to her. The IG found that the officer was exonerated because CPD patrol standard policies and procedures does not address the state of dress of a suspected burglar. There's no policy that requires a female officer to be called on the scene, and the IG believes that the responding law officers did take measures to minimize the exposure of the complainant. Therefore, the officer should be exonerated. Our conclusion was that we disagreed. We recommend additional training of the officers due to their unreasonable behavior in light of City Rule 8. The complainant should have been allowed to cover herself. A simple inquiry regarding what she was doing there, proving her right to be present in her own home, could have easily been taken. We recommend, in addition, a review and revision of the policy regarding how to treat people who are unclothed. She was obviously not carrying a weapon. There was no reason that she could not have been covered before taken outside. So we are moving for a review of the policy regarding how to treat people who are unclothed, and we're recommending additional training of the officers due to what we believe is unreasonable behavior.
Second?
Second.
Second. And before, I want to call for questions, but there was a reminder. At our last meeting, we heard City Rule 8, and I believe, although it wasn't on the agenda, that I believe Mr. Tobias and Ms. Ross were going to do a presentation to us about Rule 8.
Yep.
Is correct? Am I correct? So it appears that we're going to have that, the second meeting in February. Please, I'm placing you on the agenda.
Thank you.
Okay. Now, any other questions?
So I think you said the review. Did you also suggest the revision of the, I mean, because I do think
Review
that's-
and revision,
okay,
yeah.
Yeah, 'Cause that, some,
How to treat unclothed persons.
Yeah.
Any other questions? All in favor of the motion? Motion passes.
This is case number 2022-0331. It was filed on September 21st, 2022. Complainants allege that the officer canceled their call for service. The facts are that the complainants asked the police to respond to an issue they were having with an elementary school principal. Call was canceled by the police. Apparently, these complainants often complain to the police. Computer-generated dispatch report revealed that the officer's supervisor informed the dispatcher that neither he nor his officers were getting involved. Supervisors and sergeants have discretion concerning responding to calls for service that do not imperil citizen safety or security. The finding was exoneration. Our conclusion was that we agree the officers did not violate any CPD policies or procedures, and therefore we move that the officer be exonerated.
Is there a second? Second. Questions, discussion? All in favor of the motion? Thank you. Motion passes.
Case number 2022-0355, filed on September 29th, 2022. The complainant alleges that the officer made threats to her son. This was a custody battle between the complainant and her son's father. Body cam did not support the plaintiff's claim that the officer threatened her son. She further alleged that the officer called her a liar. The body cam did not support this allegation either. Based on the evidence, the IG recommended that the officer be exonerated because there was no evidence of a violation of CPD policy. We agree, and I motion that the officer be exonerated.
Is there a second? Is there a second? Questions, concerns? All in favor of the motion passing? Motion passes.
This is case number 2022-0361, filed on October 3rd, 2022. The complainant alleged that the officer did not complete an accident report after the complainant told him that the other driver did not have a driver's license or insurance. Our review of the body cam footage showed that the complainant never mentioned to the officer that the other driver did not have a driver's license or insurance. The complainant was informed that because there was no injury, officers would not take a report. The officer was exonerated based upon the training bulletin in place, along with policies for handling traffic crash investigations. The officers acted in accordance with CPD policies and procedures. And so, as I said, the IG recommended that this case be closed with a finding of exoneration. We agree, and so I move that the officer be exonerated.
Second? Second. Questions, concerns? All in favor? Motion passes.
Finally, this is case number 2022-0374, filed on October 10th, 2022. The complainant alleged that the two officers failed to remove her ex-boyfriend from her home, even though he had physically assaulted her. In addition, her ex-boyfriend had warrants against him in Fairfield County, and that he should have been arrested after the officers left and discovered that he had warrants against him. The boyfriend then physically assaulted her again and destroyed her property. The officers did not believe that they could remove the boyfriend from her home because of residency laws. In addition, the warrants that were verified were found to be in-county pickup only for Fairfield County, and therefore the officers could not arrest the boyfriend for these active warrants. Because the officers acted in accordance with CBT policy, it's recommended that a finding of exoneration be applied to both allegations. Our conclusion was we agreed with the IG's report, but we do recommend a review and revision of police policy in regard to domestic violence allegations.
Are you more specific than that?
So,
Go.
I can help. So,
Please.
so the issue was that I think it was the boyfriend or I'm not familiar, but he didn't leave the premises, and so after the officers didn't make him leave the premises, but after the fact, he then assaulted the victim. And so what we were suggesting is that those policies and procedures should be reviewed and or changed in order to effectively address those situations so that we prevent assaults from DV victims in the future.
And I'm going to press you specifically on what needs to be reviewed. The decision that the police made before they left, because they didn't come back, right? After she alleged she was assaulted, after they departed?
I believe so. I think they did come back the second time after the fact. And what I think she wanted them to do, he had property, I think he wanted to get, or something he wanted to get. And we talked about how right now, at least it reads as though there's nothing that would protect a person who's complaining about a domestic violence situation and says, hey, I don't feel comfortable with them being here. Can you all either stay here while they get their stuff and then they go, or can you prohibit them from being here when there's this allegation? Then the officers leave, and then he assaults her.
So then there was the officers then came because there
Came
was
back.
a report that was filed or complaint that was filed. And then the second responding officer said he shouldn't have been able to come back or remain at the premises. So it was, they didn't have the same.
Did charges come out of the second incident?
Yes.
I can't recall.
No, out
was
of
the
the first
assault.
incident, that the fact that they didn't remove him and that they found as they left the premises that there was a warrant, there were warrants in another county, but they didn't come back and do anything about it.
Yeah, they said they couldn't do anything about those warrants. So when the officers left after the first time, then he assaulted the victim, and then officers were called again as a result of that assault.
So there wasn't an alleged assault on the first incident?
I'll get the case with more specificity. Our concern was that people are left unprotected based upon this kind of, situation. So, let's see here.
Well,
The reason I'm asking, the preferred course of action is arrest in DV situations. But if she was just wanting him to leave because she's mad.
She alleged that he had physically assaulted her.
Oh.
That's what's in the summary,
Okay,
that he had already done that. In addition, she said that another officer came and told her that he had earlier warrants. And so she claimed that he had physically assaulted her, that he had backhanded her. And she called the police, 2 officers came. the officers told her he's a resident, they could not remove him. And in addition, they later learned that there were warrants outstanding, but they were in-county-only pickups. He then, after the officers left, physically assaulted her again and destroyed her property.
Gotcha.
So I know that our general counsel has been out of the criminal division of the city attorney's office for quite a while. I heard Member McIntosh use the phrase preferred arrest, which was the policy when I was involved with those types of cases. So, pardon? It still is?
Yes.
And with that knowledge then, I mean, if it's, I guess I'm having a little bit of an issue, I guess, of asking it would be the police chief, I mean, around, I think it was reviewing policies or doing something. It sounds more as if this officer or officers in the first incident maybe failed to arrest. Now, again, we weren't there, but I'm trying to think of what the appropriate remedy really is here.
Yeah, I mean, I'm not sure,
So again,
if
you're
this is just
asking the chief to do what?
to review domestic violence procedures and,
Okay.
and whether there needs to be a updating of these
Okay.
procedures to protect,
Okay.
Victims.
Okay, so there was a motion, there was a second, right? Second. Any other questions? All in favor of the motion? Yes.
I'm sorry. Just wanted to add some additional information. I have the investigator who's here that did the investigation, and so one of the things that we've always said is good to ask us questions so that there can be clarity, because there's a little bit confusion of the facts that were discussed. So I would like the investigator to just clear up one of the facts that was discussed that's not correct.
Well, it sounds to me
I know.
that the recommendation is around reviewing policies around DV cases and essentially whether or not this maybe should have been on arrest or not. So I don't know if there's anything that the investigator is going to add. I mean, they're not talking about specific training
No.
for the officer. This is taking a look at this situation. So is there a fact that goes to the point of this motion?
Yes.
Yes,
Vote on the motion, and the motion is passed.
that's true. But again, these are always educational opportunities for us as well as the investigators. But I agree, and we have come to a point where we're going to take a break. It is 3:47. Let's try to come back at 4 o'clock.
So now.
thank our general counsel for letting me know what hasn't happened. So I said earlier, the whole thing with Mr. Aragon about how he didn't appeal, and I thought that meant he was no longer on the board. But there needs to be another step, which has not occurred. Evidently, it's the mayor's office that needs to prepare, I would say, a resolution that goes to city council approving his action, and that has not occurred. So at this point, Mr. Aragon is still a member of this board. So until I don't know when, until they take action, and I will look into that, please continue to send him meeting notices.
Chair, may I just ask for a point of clarification? Does that mean that Mr. Aragon can attend the meeting?
Yes, he can. And I think technically he could attend committee meetings until that action is taken. Mr. Strickland, your team is up.
Hello. First, our team's first case is complainant towards complaint number case 0160. On August 16, 2022, the Inspector General's office received a complaint alleging excessive use of force during during her arrest by Columbus Division of Police officers. On August 17, 2022, the complainant was interviewed by the Inspector General's office regarding her allegation. According to the complainant, she was parked behind an undisclosed location with a flat tire. The owner of the property she was parked behind approached her with a baseball bat in a threatening manner. She was parked, so she left the area but backed into a pole before driving off. The complainant eventually parked in a car wash bay, and as she sat in the bay, she was surrounded and blocked in by 2 Columbus police officers. A Columbus police officer approached her driver's side door, told her not to move, opened her door, and pulled her out of the car. The complainant stated when she was pulled from the vehicle, her foot was injured and became swollen by the next day. She further stated that her handcuffs were too tight, which caused her pain and marks on her wrists. The complainant was placed in a cruiser and alleged that she complained to the officer that the handcuffs were too tight, but further alleged that he did nothing. The complainant also complained to the officer, to another officer, who then loosened her handcuffs. So, the body-worn camera footage reviewed by the Department of Inspector General revealed that the complainant was removed from her car without incident and that she did not complain of her foot or ankle when she was removed from the car. She complained to one of the officers that he was hurting her while she was being handcuffed. She was turning back and forth, and the officer told her to, quote, quit squirming, end quote. Once the handcuffs were on her and she was placed into the police car, she was asked several times if she wanted or needed medical attention, to which she declined. The complaint of her handcuffs being too tight was to one of the officers, but that officer immediately checked and loosened the handcuffs. The investigation was not able to determine whether or not her foot was injured during the arrest, due to the complainant being involved in a hit-and-run accident prior to her arrest. In addition, no complaint was made to officers on the scene about her foot, and medical aid was offered on several occasions. Therefore, it is recommended that officers be exonerated of allegation 1, which was that the officer pulled her from the car, injured her foot, and exonerated of allegation 2, which is the alleged that the handcuffs were put on too tightly and that the first officer did not loosen or check them when asked. As a subcommittee, we agree with the Department of Inspector General's recommendation of exoneration of both allegations. And so make a motion to approve of the recommendation of the Inspector General's Office of Exoneration of Allegations 1 and 2.
Any questions, concerns from any members of the board? Then all in favor of the motion? Motion passes.
The next up we have is case 0205. So I'm skipping the 2022-205. On August 17th, 2022, the Inspector General's office received a complaint from a doctor who is the attending physician for one of the alleged victims here. The doctor asked that a report be filed after her patient told her that she was taken to the ground by 3 male officers and that all 3 officers put their full weight onto her. In the complaint, the doctor noted that the alleged victim had several bruises on her head, back, and knees. The doctor also noted in her report that the bruising was consistent with the story being told by the alleged victim, and in her opinion, if true, excessive force was used on her patient. The complainant's, or the patient's mother was contacted to confirm that she was aware of the allegation by the doctor and to confirm that she would like to proceed with the complaint. So for clarity, the actual complaint was submitted by the mother on behalf of her daughter after hearing from the doctor who also contacted the Department of Inspector General. So the investigation revealed the following. A review of the body-worn camera footage showed that when the complainant tried to run from the police, she was caught and the officers attempted to handcuff her. She continued to struggle against them, and then an officer took her to the ground. One officer had the complainant in a handcuffing position with her stomach to the ground and a knee in the lower back, while another officer was squatting next to them. Both of these officers took the complainant into custody. She continued to struggle against the officers while being handcuffed and while the officers carried her to the police car. After she was placed into the back seat, once the door was closed, she hit her own head against the bars of the window several times. Based on the information received during the investigation, all 4 officers' actions and responses taken during the incidents were in accordance with CPD policy and procedure. Also, there's no evidence to support the allegations reported by the complainant's mother that she was taken to the ground by 3 male officers and that all 3 officers put their full weight onto her. It is recommended that a finding of exonerated be applied to the allegation against all 4 officers. So this one is a conversation that we had amongst our subcommittee, kind of concerned in terms of some of the handling around just even how this was presented, this idea that there was no evidence to support the allegations that she was taken to the ground by 3 male officers and that all 3 officers put their weight onto her, even though even in their summary, they says that there was a struggle and that she was brought to the ground. So that was one of those situations where, we had further questions about why there's discrepancy between the summary and the allegation itself. But moving forward, the recommendation here is a finding of exonerated that is applied to all 4 officers. So I wanted to open that. I don't know, Mary, if you had further.
We talked about this long and hard because the fact that the doctor brought the allegations and the bruising on her body and what the doctor indicated, they coincided. And so, but then the IG, with the body-worn camera and the reports, the medical reports and everything that the IG reviewed, we decided that, and what the young lady did to herself by banging her head against the cruiser window, and everything that she did to evade arrest. The officers had to kind of move her and move her arms to get her to effect the arrest. That the officers did what they needed to do without using excessive force, and that's why we went along with what the IG did here.
And so, but again, I mean, this is our subcommittee having these questions on the initial, these were kind of the initial cases before that first meeting where this was reviewed. And I think this is where some clarity as to around why the summary said one thing and then the recommendation seemed to conflict the summary.
Madam Chair?
Yes.
When you were reading the report, I think the report states what the body cam footage showed. So the inconsistency came from the allegation that the complainant made to the doctor based on the injuries. And so when we got the investigation and the body cam footage was pulled and reviewed, the body cam footage showed what happened, and it didn't support the allegations by the complainant's daughter. And that's why our findings were exonerated, because there were not 3 male officers. As she stated, there was only 1 male officer that actually ended up taking the complainant into custody.
Yeah, thank you for that. And so, I do, want to put forth for a discussion among the board in terms of there was an allegation, those specific allegations that was made among the complainant, and there was also an incident here where it was a different situation that occurred in this struggle. And so I just want to make sure that there was no further concerns there among the board members. Good? All right, so we're going to move ahead. Yeah, well, I'm gonna. So part of, and I don't know if this is part of the recommendation in this vote itself, but one of the questions that I would have is just clarity around, even if a complainant doesn't make a specific allegation, if there are other situations that are that occur that may be a violation. I've noticed that in some of the investigation memos, those are also included, and then others, it's not. It's not always consistent, and I understand that there's different investigators, but that was one thing that I noticed that I think it might be additionally helpful to clarify on.
Madam Chair, so one thing, and to your question, sir, one of the things you will find is when they view the body cam footage, if we see additional allegations that the officer is involved in, we definitely note that. And I think as you started going through the reports, you'll notice there's additional things where we might see mishandling, either in language or how somebody handles a person being arrested if something's added. So anything additional that may not be a part of the initial allegation, if we observe that in our investigation, whether it's in statements, body cam footage reports, we note that, and that is usually the additional findings that will be mentioned in the report, because it may not be the initial allegation, but it would be our findings, because anytime we handle any investigation we do, we look at the whole circumstances.
Excellent. All right, thank you. So we'll move ahead with the IG office's recommendation of exonerated of the allegations of 3 male officers, and that all 3 officers put their full weight onto her. And it's recommended that a finding of exonerated be applied to the allegation against all 4 officers.
And that's in
It's
the form of a motion?
It's in form of a motion.
Second?
Second.
Any further questions or concerns? All in favor of the motion? Thank you.
Case 201, on August 23rd, 2022, the complainant filed a complaint with the Department of Inspector General's office alleging misconduct by Columbus police officers. The complainant alleged that CPD officers did not appropriately handle an incident where her car and her neighbor's car were struck by a truck. The complainant believes that the officers should have performed a field sobriety test on the driver of the truck, who appeared to be intoxicated. The complainant also alleged that the officers refused to give her and her neighbor an exchange of information form regarding the incident. entered information incorrectly on the accident report and threatened to arrest her if she did not move out of the way. After a review of the Columbus Division of Police Policies and Procedures, the body-worn camera footage, and information obtained from the statements of the officers, the investigation found no violation of CPD policies and/or procedures as it relates to the following allegations. 1, the officers did not administer alcohol testing. 2, the officers entered information incorrectly. And 3, the officers threatened to arrest the complainant. Again, so they believe that in those 3 instances of not administering alcohol testing and officers entering information correctly and the officers threatening to arrest the complainant, those are recommended of allegations of closed with a finding of exonerated. However, the investigation revealed that I just want to be clarify. The investigation revealed that 3 officers did fail to provide an exchange of information, which is a violation of CPD policy and/or procedure. Therefore, it is recommended that this allegation be closed with a finding of sustained. And so just want to be specific on that recommendation based on that finding. In reference to allegation 3, which is where they made the finding that the responses were not in accordance with CPD policy and/or procedure, therefore, it is recommended that the investigation into allegation 1 against the officers be closed with a finding of sustained. However, it should be noted that the Department of Inspector General has investigated similar complaints where other CPD officers have stated that it is common practice to provide the information on how to obtain a copy of the report rather than providing the exchange of identification information to the individual. For that reason, it is the IG's recommendation that the language in CPD's current policy be updated to reflect their common practice and/or to provide instructions to CPD members regarding CPD policy and procedures regarding this matter. Finally, it is recommended that this investigation report be forwarded to the City of Columbus, Director of Public Safety and/or Chief of Police, CDP for review and the consideration of disciplinary action in accordance with CPD policies and procedures and the collective bargaining agreement between the City of Columbus and Fraternal Order of Police Capital City Lodge 9. I would make a motion to agree with the recommendation of the Inspector General of allegations 1, 2, and 4 closed with a finding of exonerated, and allegation 3 closed with a finding of sustained, along with the forwarding of this report and the recommendation that CPD's policy be updated to reflect common practices or instructions to CPD members regarding current policy.
I just have a question. At some point there towards the end, I heard language about the FOP in the contract, which is not in the motion. So could you just clarify what were you referencing?
I'm referencing the recommendation on the IG memo. So it's recommended that the language, I think this is, my understanding was this is part of the standard practice if there is a recommendation from the IG's office that the report be forwarded to the City of Columbus, Director of Public Safety and/or Chief of Police for review and the consideration of disciplinary action in accordance with CPD policies and procedures and the collective bargaining agreement between the City of Columbus and Fraternal Order of Police Capital City Lodge 9. So maybe even when we think about, as we give our recommendations, I don't know if we have to use this standard language, but that to me, I think, is the standard language that was provided here.
Okay. Questions? All in favor of the motion? Passes.
We have 0220 on August 31st, 2022. The Department of Inspector General opened a complaint alleging police misconduct / neglect of duty. According to the complainant, on August 30th, 2022, between 7 p.m. and 7:30 p.m., she was involved in a two-car automobile accident at the location near Chittenden Avenue. The complainant alleged the following: one, that one of the Columbus police officers and male officers and a female officer arrived at the accident and did not do their job. 2, the female officer was very rude and told her she was not talking with her. 3, she asked the female officer her name and she refused and walked away, and she feared for her safety. The investigation revealed that the Columbus police officers' actions in response to the accident were supported by CPD policy and or procedure. Therefore, it is recommended that the allegation be closed as exonerated. The investigation found no evidence to support that the complainant's allegation that the female officer or any officer was rude or refused to give their name during this incident. Therefore, it is recommended that these allegations by the complainant be closed unfounded. So just want to clarify those because there were a set of different allegations here. It is recommended that so I just want to clarify. So regarding the actions taken by the officers and their response to the scene was in accordance to CPD policy and or procedure. And so that finding is closed with exonerated. And the investigation also found no evidence to substantiate the complainant's allegation that one of the officers was rude or discourteous or refused to provide her name to the complainant, and that these actions made the complainant fear for their safety. It is recommended that in this allegation be closed with a finding of unfounded. So would move forward with a motion that the allegations of the actions in response to the accident were supported by CPD policy and procedure, so it's recommended with the closing of exonerated, and the allegation of rude behavior be closed with a finding of unfounded.
May I ask?
Yeah.
Was there body cam footage here so that there was evidence or no evidence, or what was the foundation for saying that she never refused to give her name? She didn't refuse to give her name, or she was not rude?
Yeah, in review there was body-worn camera footage, and the review of that, according to the investigator, was that there was no evidence that corroborated that the officer was being aggressive or in any way irritated toward the complainant during this incident. Now, I will say, and this is something that is part of this, but also thinking about consistency moving forward, we have noticed that in some of these cases, the officers are not interviewed. And I've seen that across the board on a number of these instances where there were officers that were not interviewed, but instead the body-worn camera footage was kind of the determination. And so I did have and I know we can ask these point of clarifications later, but I did have a point of clarification just for the IG's office in terms of when particular incidents warrant further investigation interview versus if you think the body-worn camera footage might suffice. Mr. Chairman.
Thank you so much. So normally, in any investigation that we conduct, if the allegation is such that the body-worn camera gives us the ability to see what actually occurred in the incident and it does not call for us to interview the officer, then we won't bring the officer in. But if we have questions and there are investigations that there are allegations where some of the questions are not able to be clarified with the view of the body cam, so therefore we will request that the officer come in and interview them.
Excellent. Thank you. So I'd like to move forward. I don't know if maybe you had further questions. I'd like to move forward with a motion that allegations, one, which is the Columbus police officers arrived at the accident and did not do their job, be closed with a finding of exonerated, and that allegations 2 and 3, which is the allegations that the officer was very rude and not talking with the complainant, and that the complainant asked for her name, and the officer refused and walked away, making the complainant fear for her safety, be closed with a finding of unfounded. So we agree with the recommendation of the Inspector General's office here.
Is there a second? Thank you. Questions, concerns? All in favor of the motion? Passes.
The next up we have, I don't know if this matters. This thing fell off. I don't know if, I'm not sure. I'm not enough of a tech person to know if that makes a difference, but.
I think he's saying let it go.
Okay, cool. Thank you. The next we have is 0305 on September 13th, 2022. The complainant, which is one of the community association managers, filed a complaint with the City of Columbus Department of Inspector General's office alleging misconduct by Columbus police officers. The complainant alleged that CPD officers had refused to respond multiple times to the neighborhood when he was contacted by residents. The investigation in this case revealed no evidence that substantiated the complainant's allegation of officer misconduct, and therefore they make a recommendation finding of unfounded. So dig a little deeper into this case just so that folks have a little sense here. Is the first allegation was that the officers refused to respond multiple times to calls. So according to the complainant, multiple neighbors had contacted CPD within a 2-week time period, and CPD refused to respond regarding issues in the neighborhoods. The complainant went on to state that there had been 3 instances where there was an issue. For the first instance, the complainant stated that 2 neighbors called and were informed by a dispatcher that their call for service involved an HOA issue. After an additional 3rd call was placed, the complainant stated that the dispatcher sent an officer out. For the 2nd and 3rd instances, the complainant stated that the police, quote, refused to respond, end quote, to calls for services involving drug-impaired individuals in the area. The complainant was only able to provide the investigator with the name, address, and phone number of one of the neighbors who had called, but the complainant was unable to recall the specific dates that he called, but believed it was, 4 weeks prior to the beginning of October. Based on this information, the Inspector General's office sent a request to the Emergency Communications Center, and the ECC, the Emergency Communications Center, was unable to locate any calls for service to the given address or to the addresses on the given cross streets all the way back to July 1st, 2022. And so based on this information, the investigator was unable to find any evidence that supported the complainant's allegation. Given that it is reasonable that some calls to 911 will not amount to dispatch calls for service, quote, or parentheses, such as the first 2 calls placed in this first instance, it is possible, though, that calls were made by the neighbors, but that officers were never dispatched. However, officers are not responsible for which calls are dispatched and which are not. The Emergency Communications Center is. Therefore, if that was the case, no officer misconduct nor violations of CPD policy and or procedure would have occurred. It is recommended that these findings be passed along to the Emergency Communications Center for review to determine if any ECC policies and or procedures were violated regarding dispatch calls for service. So the conclusion here is that there is a recommendation that the allegation be closed with a finding of unfounded, and that no violations were discovered throughout the course of the investigation. However, it's recommended that this investigation report be forwarded to the City of Columbus Director of Public Safety and or the Emergency Communications Center manager to apprise the department of this matter. So I'd make our subcommittee agrees with the recommendation of the Department of the Inspector General. I'd make a motion with the allegation of unfounded and the forwarding of the report to the City of Columbus Director of Public Safety and or the emergency, well, I would say and, the Emergency Communication Center manager to apprise them of this matter.
Second.
Questions, concerns? All in favor indicate by saying aye. Raising your hand. Forgot what meeting I was in. Your next case?
0337, on September 26, 2022, the complainant filed a complaint with the City of Columbus Department Inspector General alleging excessive use of force by a Columbus police officer. The complainant alleged that a CPD officer shoved her to the ground, causing her ankle to get pinned under a vehicle's tire, which resulted in a sprain and a blood clot. The investigation revealed that two officers responded to the alleged incident. After a review of the body-worn camera footage, it is recommended that the allegation against the officers be closed with a finding of unfounded, as the investigation found no evidence that substantiated the complainant's allegation. However, and this is kind of an example we talked about earlier, the investigation revealed that one of the officers did violate CPD policy and/or procedure by not activating his body-worn camera during the interaction. So just a little bit further detail on this situation here. So the investigator was unable to obtain more information from the complainant despite several attempts, but the initial voicemail left by the complainant contained enough information, date, location, and incident number, for an investigation to be opened. And the complainant reported that 4 officers and 3 cruisers responded. However, this investigator was able to determine that only 2 officers responded to the call for service. Per the computer-aided dispatch report, the call for service was entered in as a 16B, which is code for a disturbance/mental run. The details of the run stated that a female, likely suffering with mental health issues, had been in a parking lot for 60 to 90 minutes. The body-worn camera footage for one of the officers was reviewed, but there was no footage for the other officer. The body-worn footage revealed no evidence that substantiated the complainant's allegation, as in the footage, the officers can be seen arriving in and entering where the complainant can be seen gathering her bag at the register. The officers briefly had a conversation with the complainant, asking what she was doing there, and the officer offered to carry the complainant's bag to her trunk. As she gets into the driver's seat of her vehicle, the officers briefly speak with the complainant again, and she informs them that she's going home. One of the officers can be heard telling her to not come back to that same area, as those employees of that area will call again to report her being there. The complainant understood, and as the video ends, the complainant can be seen being completely seated in her vehicle as the officers walk towards their cruiser, telling her to have a good day. So at no point did the footage reveal that this interaction showed the complainant being pushed or shoved to the ground by either officer. However, and this is the motion we would make, based on the information reviewed, the allegation against the officers be unfounded, as there's no evidence that substantiates the complainant's allegation. However, the investigation revealed that one of the officers did violate CPD policy and/or procedure, specifically Columbus Police Division Directive of 1107, by not activating his body-worn camera during the interaction. And so, based on that, the Inspector General recommends that this investigation report be forwarded to the City of Columbus Director of Public Safety and/or Chief of Police, Columbus Division of Police for review, and the consideration for disciplinary action in accordance with CPD policies and procedures and the collective bargaining agreement between the City of Columbus and Fraternal Order of Police. That would be the motion for the findings of unfounded and the forwarding of the report, or findings of unfounded for the complainant's allegation, but the finding of, and I would need some clarity here of, do you sustain that? Did you then create an allegation and sustain a filing, or do you just say an investigator was violated policy.
Thank you. So normally, if we find something additional, the only reason we don't do a recommendation of exonerate or sustain because it was not the initial allegation. So our finding is this is additional to what we found and that we note that it was a violation. And so our recommendation then follows that it still goes to the chief of police. And if we were to get an allegation and sustain that, then it would be in addition to, it would stay, this was sustained, and in addition to our additional finding, and still putting all of those recommendations being forwarded to the chief of police for her consideration in accordance with the collective bargaining agreement.
Thank you for that. And I think just kind of a general question I would have for the board in terms of when that does occur, do you have thoughts on moving forward with putting forth an allegation of sustained with the allegations that were made here? Only because I just want to know how we're documenting a particular situation, because if somebody doesn't make an allegation, but had they had made an allegation, it would have been sustained. And so I just don't know if there's a difference there. I don't know if anyone has thoughts on that.
For clarity,
Yes, Ms. Ross?
Board Member Strickland,
Yeah.
are you proffering that the board actually make an additional allegation based on the finding of the IG?
No,
And then sustain that allegation for the body-worn camera?
So
footage?
it's more so in terms of the way in which we're collecting data consistently. And so, and in this instance here, if there was a determination that an officer violated CPD policy, but that was made in like the finding, is that going to be on anybody? Like, I don't know in terms of, how is that going to be
Got it.
measured basically, or?
And the solution would be that the IG make an additional allegation, or that the board, based on the IG's finding, motion to create an additional allegation and then sustain it based on the findings of the IG?
I'm not sure the best way to do it. I just would recommend that if somebody violated policy, that there is a notice of that as like a violation of policy, instead of just like it was kind of part of the finding and they didn't make.
So this came up during the investigation, and we've said very clearly that when you're investigating, other matters can come
Right,
up, and you're going to investigate them. Then I'm not sure why you couldn't have that as an allegation.
Right.
And recommend certain things specifically to us. Not that we would go through the process, but that you would do that.
And that's what I'm asking. I'm not saying I disagree with that. I just wanted clarity so that we can know for the next time that we see an additional violation that may not have been alleged by the
Yes.
complainant, do we create a new allegation and then
Yes.
sustain that so it's clear
Yeah.
and that it can be tracked?
Yes.
That would
Correct?
be helpful.
Excellent.
Yes.
Thank you.
Should I move ahead with this or?
And so just to clarify, inasmuch as the IG is appointed by the board and that we can, we have the authority by the ordinance to file a complaint, they would have delegated authority to do that. Is that what we're saying?
That's a fair question.
I'm sorry, I'm one of those common sense kind of people.
No,
I think it's common sense. I just want to make sure that we're following the ordinance. I think it makes total sense for us not to go through a lot of hoops to add. I'm just wanting to make sure that the procedure that they were laying out is something they can actually do. And it seems to make sense. If you're working for us and we have the authority to do it, we delegate that authority to you.
So
I just wanted
between
to.
now, that's what I think, but between now, I mean, really very quickly, I'm going to go back and confer with the city attorney's office on that. Again, I don't want people to wing it. I mean, there's no way we can, at least not for me, that I can remember every word that's in the ordinance, et cetera. So we'll move forward today, get a definitive answer that will be relayed. Okay?
And that's helpful. Again, I think even as we report these out, I mean, still being clear that there was a finding that there was a violation of CBD policy. So just thinking about how we track, how we're thinking about data collection and tracking, we can think about whether there's violations of particular policies. So I make a motion to agree with the Inspector General's report here that the initial allegation itself was a finding of unfounded. However, there was a violation of CPD policy and/or procedure, and so as a result of that, it's recommended that this investigation report be forwarded to the City of Columbus Director of Public Safety and/or Chief of Police. I would just add "and Chief of Police" for review and the consideration of disciplinary action in accordance with CPD policies and procedures and the collective bargaining agreement between the City of Columbus and Fraternal Order of Police Capital City Lodge Number 9.
Questions, concerns? All in favor of the motion? Motion passes.
All right, a couple more. Almost there. This is 0360. On October 3rd, 2022, the City of Columbus Department of Inspector General received an email complaint by one of the complainants that alleged an officer who gave her a parking ticket was very rude and hostile toward her. She stated she hadn't been stopped long enough to read the sign where there was no parking days and hours were posted, and that the officer also refused to provide their name to her. A review of the body-worn camera footage revealed that the complainant was fully stopped with the passenger door open and someone standing outside of the vehicle, and there was someone standing outside of the vehicle when an officer turned around from the other side of the street and initiated a traffic stop for the parking violation. The officer was never asked for his name or badge number during the stop, and the officer was not perceived as rude or hostile during the interaction, according to the investigator here. The Department of Inspector General therefore recommends a finding of, quote, unfounded be applied for the complaint of being rude or discourteous, and, quote, unfounded for the complaint for failure to provide a name and or badge number. I did want to go in a little further detail here in terms of this particular incident. Just want to make sure I'm clear here. The complainant stated that the officer, when there's interaction between the officer and the complainant stated that the officer refused to provide her with his name, and that he also, quote, misgendered her as sir after she'd corrected him twice. She described the officer as being nasty and intimidating. She stated that the officer raised his voice at her and yelled that he did not care. She stated that he did not request any documents from her and that he did not have time to run her plates or anything, so she thought that was very unusual. Every time she tried to request an explanation from the officer, she alleged that he raised his voice in an abusive and threatening manner. She stated that she and her friend were fearful that the officer was going to physically harm them. She stated that she quickly rolled her window up out of fear after he told her to leave, and she also stated that she saw he had left his turn signal on and that he moved forward and touched her bumper. She stated that she was waiting for him to pull out, but that he pulled up next to her and yelled at her to leave, and she told him she did not want to leave until he left. She then stated that she was standing in a matter of inches from her and that he yelled at her that he would impound her car and write her another ticket in 30 seconds if she didn't shut her mouth and move. According to the investigator's review of the body-worn camera footage, it revealed that the complainant's vehicle was fully parked, and that the complainant never at any point asked for the officer's name or badge number. The officer refers to the complainant as sir twice. The complainant corrected the officer by saying, quote, miss. The officer then referred to her as ma'am throughout the interaction. The body-worn camera footage shows that the officer was not rude, nor was he intimidating or threatening. He began writing the parking ticket as he explained that they could not park where they were on game days between 4 p.m. and 1 a.m. He did not raise his voice or argue or yell. Once the officer gave her the ticket, he told her that she had to move and got on his motorcycle. He waited for several seconds, and when the complainant did not pull off, he pulled up next to her and stated that she needed to move. When she told the officer that she was waiting for him to get out from behind her, he stated that this is what officers did and that he was making sure the lane was clear. He then told her to go forward. The complainant stated, quote, "You don't need to harass me." The officer replied, quote, "I'm going to tow your car in about 30 seconds, ma'am." The complainant then proceeded forward and drove off. So, according to the conclusion of the recommendation here, the investigator says that the complainant's vehicle was parked under a no parking sign and a passenger was outside of the vehicle, and the officer called the complainant sir, but corrected himself when the complainant clarified that it was miss. Therefore, the Department of Inspector General recommends that a finding of unfounded be applied to the allegation of officer being rude or discourteous, and that the officer was not asked at any point during this interaction for his name or badge number. Therefore, it is recommended for a finding of unfounded be applied to the allegation of that the officer did not provide name and or badge number upon request. So, in this situation, I do want to open up for discussion. I know before I make a motion, I don't know if.
What's the topic of the discussion? I mean, you're
I don't know,
leading
any-
it. It
yeah, I
should be a
mean-
report.
What's that?
I said, you're the chair. Are there questions that you want to ask of the board members, their opinions or whatever?
Yeah. Did you have any questions or opinions regarding this particular case?
It seems very clear that through the body-worn camera that the officer, was not rude, and the evidence does not show that he failed to identify himself, and he was very courteous when he stayed behind to make sure the lane was clear so she could pull out into traffic.
Okay. Any other?
I mean,
Do you have motions?
no.
no, he said in this particular case, he felt he should open it up for discussion. I then asked Mr. Strickland, kind of like, I don't want to say what was the purpose, but
Yeah.
you must have had a reason for stating it that way. From Member Fluharty, he thought it was pretty straightforward, so I'm trying to figure out your concern here.
Well, no, exactly. I just, in terms of the, I guess this would be a little bit further clarity in terms of when it's written as a report. It says specifically, the complainant alleges that the officer yelled at her that he was going to tow her car. But then the conclusion of the review says that, he says he was going to tow your car in about 30 seconds, ma'am. And it didn't explain, like, did he yell that or did he just say it casually? And my presumption here is that it was a casual because because it said that he was not being rude or did not raise his voice. But that's one thing that I, would love a little bit more clarity on.
So one of the things that we try to do when we're doing our reports is when we talk to the complainant and the complainant makes an allegation that the officer is rude, we try to get clarification because we need to understand, what do you mean the officer is rude? Because the officer may be talking loud if they're on the freeway because the officer wants that complainant to hear what's being said. So what you will find is we ask specifically what the allegation is, and that's why we will put that in writing so that we understand what we're looking at. And then when we start looking at the body cam footage or any additional questions that the body cam footage, let's say, may not cover, and we talk to the officer, then we're just trying to get clarification. So that might be, and I don't know if that answers your question, why you might see inconsistency as to what the allegation is, so that we specifically know what we're looking at, and then based on the conclusion, what we find based on what we review, and the conclusion is in the investigation.
I think.
In your investigation of the body-worn camera, did you conclude that when the officer said, "I'll tow your car in 30 seconds," that he was being rude? Just a simple yes or no, please.
No.
Thank you.
Yeah, no, and so that was helpful. I was just more so trying to get a sense of what the, I mean, it seems like a subjective determination, and there are policies that, and precedent that determines whether or not a particular situation is rude or not. And so my understanding is that it did not rise to the level of a policy violation here.
It would appear to me that during the investigation, whoever the investigator was, they viewed the body cam. And so that person would have been able to determine from viewing the body cam whether it was rude or loud or whatever. I mean, there's the allegation, and then there's, again, the investigation where the body cam will show that she wasn't being truthful.
Well, I will say on that, though, I mean, it could be a subjective matter as to whether or not somebody believes somebody was rude or not. And so I was just trying to get a sense of the consistent practice across investigators. And again, this is why you have the teams that review it and review it again and say, we agree with the recommendation here. But I just did want some clarity on that. So that was helpful.
I think basically here, it's the officer's discretion as to whether he's going to give a ticket to these two people or not. But I think our committee discussed this, and the officer, said, if you don't leave, I'm going to tow your car in 30 seconds. Now, I don't know what tone of voice he had, but I think what Kyle's trying to understand is the investigator had the opportunity to view it. So what was his tone? Because I think that the officer did the right thing. We agree with it. But I think that from this stop here, that there was an undercurrent going on, we think. We could be totally wrong, but I think that's just a feeling that we had from all the allegations that this young lady made, that something was going on. You see what I'm saying?
Was this on campus?
I think it was, Carl.
Is it on campus?
I'm not.
It said something about the Columbus the game day.
Game day?
Game day, yeah.
All right. Can we move on?
No, I mean,
It's not a big
this is a
thing, but it's.
I mean, I do think we may. I mean, we'll get it done, and I do think, though, as a discussion, as a board, just more consistently thinking about how these determinations are made, whether or not something is deemed rude or discourteous or not. Just a little bit more clarity on it. Also, again, if we do want to dig deeper, right, as a team, we can ask further clarification. And in the future, just like the last meeting, I'm maybe not to this specific incident, but even for us as a board to understand the level of deference that we're providing to the IG's office and the team of investigators and how determinations are made, whether or not something rises to the level of a policy violation. I think just even for consistency's sake, it's helpful for us to just, maybe it's a review or presentation from you all, maybe. I think that's helpful moving forward. I don't have any further discussion points about this aside from, I think this also, we should have some, when we're talking about policies and practices moving forward, thinking about traffic stops and initiation of traffic stops and those types of things. But outside of this particular situation, I think the allegations of unfounded, our group would move to accept those allegations of unfounded.
So second. Questions, concerns? All those in favor? Mr. Strickland, as it is rightfully something that you should raise, on more than one occasion in several meetings, you have said, I believe we should do something around policies and procedures. And I actually ask you to take a lead there. So this is what I'm going to specifically ask you today. Please review the last several meetings and all of the meetings, and where you have made suggestions about some things that we should do, please commit them to writing, share them with me, and then I can figure out how we move forward as a board. But it's if we're going to address them, absolutely, you should raise them. But then they need to be specifically delineated. So then I can decide what committee it goes to or whatever, because it quite frankly happens in many meetings. And again, something you should be doing. But I'm putting the burden on you for your suggestions that you've made to go back and review. Please put them in writing and I will act on them. We've come to the point in the meeting where I need to, I want to say, wrap it up. So it's a good thing we have a second meeting in February. Pardon? Oh, you have one? I'm sorry. Go ahead with your last one.
One more case, last one here. It's 0371, October 6, 2022. The complainant alleged that an officer did not conduct a thorough traffic crash investigation, and that he did not obtain a statement from him at the accident, nor did he review photos taken immediately following an accident. The complainant also alleged that the officer dismissed a witness, did not talk to him, and yelled at him when he tried to tell the officer what happened. A review of the computer-aided dispatch data and body-worn camera footage revealed that a thorough investigation was conducted by the two officers that were on the scene. No witness ever approached either officer. The officers did not argue with or dismiss any witnesses, either as alleged by the complainant. Therefore, it is recommended that the allegation that the officers did not conduct a thorough investigation be closed with a finding of, quote, unfounded. Also, no witness approached either officer. Therefore, it is recommended that the allegation that the officers were rude or discourteous to a witness be closed with a finding of unfounded. And it's determined that no CBD policies or procedures or violations by the officers during this incident were violated. Okay, so would make the would our group, our subcommittee agreed with these findings, and so we would move forward with the agreeing with the Inspector General's recommendation of unfounded to both allegations.
All those, I'm sorry, questions, comments? All in favor? Thank you. So now, back to moving forward. And you can see it's at 5, but we're not ending, because as I recall, at our last meeting, the Inspector General was not able to give a report. And I'm not going to be discourteous to her this month by not giving her that opportunity. So we will first hear from the Inspector General, and then I will deal with the cases that have yet to be heard. And I was handed 23 new cases today, and so I need to make assignments for that, and we can talk about the future meetings.
Madam Chair, I am good with not presenting anything today, if we can go forward.
Okay. And, and one of the things that you can do, and again, I don't know what it is, you can prepare a written report, because something tells me the same thing is going to happen at our next meeting, or I could, this is, in terms of the agenda, in terms of our next meeting, the Inspector General gets her report before we go into reviews. Yes, and going forward. So before I get into assignments, I just want to check with the board on a couple of items about future meetings. At one point, there was a request to have someone come in, and those two individuals were identified out of the administration to speak about the FOP and the contract and discipline. So I just need to know if, well, think about that, if that's a priority, because I'm just trying to schedule out meetings. Rule 8, you said you wanted some explanation, so I
I didn't say that. They said that.
What? Who said that?
I didn't ask for an explanation. I wanted to use
The
it.
board could use some explanation.
Yeah.
Yes, yes, yes. And we're going to have that at the next meeting. Yes. Just some things we need to be thinking about in the future, and it certainly puts a greater workload on members of the board. I think we need to really start thinking about training for new board members, because it may not be exactly the same. So I'll be turning to the training committee. I mean, again, I don't know. I would do a guesstimate that May or June, we may be seeing new board members, but that is purely a guesstimate on my part. But I just think that you should be thinking about that. We have to have present a report to City Council. We decided last year that really we didn't have anything to report. But I think this year, and we talked in terms, I think, of the month of being, April. So I reached out today, and it is my anticipation is that we would have professional assistance in preparing a report. And so I'll get moving on that with the hope that could be finished by April the 30th. If anyone is particularly interested in being a part of the report, please let me know. Please send me an email or text, okay? I think we decided that the social media policy that goes back to the committee that's chaired by Pastor Nathan. That will be presented. Did we say maybe at the February 28th?
No, I think we were thinking March.
March, okay, I did write March. And then on the rules and regulations and discipline, that might be at some point later. Is there any topic or anything maybe I've overlooked that the board wants me to put on this list? Yes.
Just shoehorn that broader policy discussion that I'm supposed to come up with writing on. I'll put that together.
I just want the list, and
Yeah,
I want
no,
the
I mean,
list by the March meeting.
Okay, well.
You present me the
get it.
list, and I'll go from there.
Gotcha.
As a matter of fact, let me just make a note of that.
We need to hand in our sign cases. Correct?
Yes. Let me get there. Just a minute. And that's going to be the March meeting, Mr. Strickland. Now, so Mr. McIntosh has completed their team meetings for, this would have been, I think, the being not able to report out today, but he also completed the January assigned investigations, where I don't believe, I know that teams 2 and 3, 1 and 2, you have not met.
We're meeting this Thursday.
Okay, so you'll meet and you'll report out. And then I do believe that it's important that I make this a part of the record. So bear with me. Case assignments. To Mr. McIntosh's committee, case, and I'm only going to read the last 4 digits, 0383, 0401, 0421, 0425, 0429, 0440, Mr. McIntosh's cases. The next grouping, would be Pastor Nathan's, 0445, 0451, 0459, 0477, 0484, 0486, 0488. And then last but not least, Mr. Strickland, 0496, 0502, 0506, 0508, 0509, 0527, 0528, 0530. And of course, you will check to make sure that I didn't skip one and will let me know in terms of the 23 cases. Is there anything else that needs, that a member would like to bring before the board today?
Madam Chair?
Yes.
I know that it's late, but Chair Member McIntosh and myself are prepared to finalize our cases today if the board is interested.
No.
So noted.
I mean, 3 hours is just a long time. So I hope we can, and it's, the one thing I never want to do is to stymie discussion, but we may need to revisit what our meeting time should be, because we don't get to the cases until, I think, almost 3 o'clock. And so that, and if that continues to be the case, we're going to have an issue. Maybe with having a second meeting, we'll be able to get caught up. So for example, like in this case, our board member, and we know this, has another board meeting and she had to leave. And I don't think it's fair to her or even to others that we just move beyond our, other than a small amount of time period. Just keep reminding me, let's keep working at it, let's see what we can do, okay?
I'll
Is there-
take that under consideration.
Is there a motion to adjourn?
So moved.
Second? Second, all in favor?